Hello everyone and welcome to this bobsguide webinar. I'm Nicole Miskelly, your bobsguide moderator today. The subject for today's webinar is hot topics in FinTech law, and we'll be looking at various key areas of financial technology law from the viewpoint of banking, securities, insurance and payment cards. We will also be addressing topics such as cybersecurity, information governance, mobile banking and cloud computing in order to gain a deeper understanding of these topics as they relate to the use of technology in the highly regulated financial services industry. Finally, while largely a US-focused webinar, the presentation will also address global issues and viewpoints. So to introduce our speaker, we'll be hearing shortly from Kevin Taylor, partner at Schnader Harrison Segal and Lewis LLP. Kevin is a highly regarded technology, outsourcing and intellectual property attorney. He has global experience with BPO and IT outsourcing, technology licensing, commercialization of intellectual property, complex commercial contracts, privacy, and more. He has also appeared on Bloomberg Television and has been quoted in the Wall Street Journal. He is also the author of FinTech Law, a guide to technology law in the financial services industry, published by Bloomberg and BNA. So before we hear from Kevin, there are a few housekeeping points to take note of. If you have a question to ask our speaker, please go to the box on your screen and simply type it in. I'll use it at the end of the hour-long webinar today, time permitting. The entire webinar will also be recorded, so if you miss anything or think a colleague would be interested later on, you'll be sent a link to the recording. Without further ado, I'll hand over to our expert speaker today. Kevin, over to you.
Thank you very much. I first just want to say I'm very happy and excited to be able to speak with everybody today and to talk about FinTech law. It's an area that I get very excited about it. There's a lot going on. There's been a lot going on, and there'll be even more going on in the future. I've represented a lot of large financial institutions in the development and purchase of technology, but I've also represented smaller companies that sell to those larger institutions, and I've seen a lot of different things over the years. And finally, last year, I decided to sit down and actually write a book on it, FinTech Law, which, as was mentioned, is published by Bloomberg BNA, but this is really just the start of it because this area is changing so much. Now today I'm going to talk and give you an overview of certain areas, certain parts of this. And I'm going to focus on mobile financial services, cloud computing, information governance, which actually has several different subparts, and then lastly, I'm going to talk about cybersecurity, which is a big issue and really affects all of these other areas as well. So what do we mean when we say mobile financial services? Well, I define it as any financial activity using any mobile device, such as a cell phone or a tablet or whatever device is invented in the future, because I'm sure someone will come up with something else. And it allows bank customers to obtain account information, to transfer funds, and even sometimes pay bills. It's estimated that mobile phones will be the payment method of choice for over 50 million consumers worldwide. The market in 2011, the market was $11.5 billion. This is expected to grow. The main technology that's used currently is NFC technology, near field communications, which we'll talk about in a minute, but there are other technologies as well. Now, initially, to give you a little history, payments in mobile phones were made through text messaging, but this would sometimes be slow and unreliable, and hence could not be relied upon for making larger payments. This led to the development of near-field communications. Here we go. Okay, so NFC technology has enabled the exchange of data between devices using existing infrastructure, which was already in place for payments. It can also work when the devices are turned off, which is similar to a credit card, right? That you don't need power in order to make the payment. It has a very short range, about 4 inches. It uses a ISO IEC 1443 standard, which is for proximity cards, contactless cards, and also RFID. And it really kind of combines the interface of a smart card and a reader into a single device. It's currently aimed at being used with mobile phones. It's used for card emulation, which simulates a smart card. It can be used as a reader and read passive RFID tags. And it also communicates directly with another NFC device so that they're exchanging information. Current uses include electronic ticketing, electronic money, travel cards, identity documents, mobile commerce, paying for your Starbucks or your new blue jeans. It can also be used for electronic keys, your car key, your house key, hotel room, and it can be used to configure other wireless devices or other wireless connections, such as Bluetooth, Wi-Fi, or ultra-wideband. There's currently a patent licensing program by VIA Licensing Corporation. If you want to use NFC in a device or in software, it's good to go there and check out the different licensing options. There's a public platform for NFC that's released under the GNU open source license. It's called libnfc.org. Now, NFC, I just want to compare it to another technology was out there, which is Bluetooth, right? NFC is finding strength in the marketplace because it has certain advantages over Bluetooth. Has a shorter setup time. It's easier to configure. The data transfer rate is slower, but in payments there's very little data that needs to be transferred. There's certain data points that need to go, but you're not transferring data. It takes as much data to transfer $1 as it takes to transfer $100. NFC has a shorter range than Bluetooth, which makes it a little more secure. It's suitable for crowded areas where getting the right signal to the right device can sometimes be difficult. And it's consistent with RFID, which means you don't always need the battery. As we mentioned, it can be used when the device is turned off. Now, there are some drawbacks. NFC can be hacked. It offers no protection against eavesdropping. It can be vulnerable to data modifications, and there can be other attacks as well. The RF signal for the wireless data transfer can be picked up with antennas, and hackers are able to eavesdrop from various distances, so it's not always easy to tell if your mobile phone is being hacked. Another way it can be hacked is data can be destroyed and modified. So really, there's really no way to prevent that attack. You can use NFC to check the field while they're sending it, but that might detect it, it might not. Now, what's the concern? The concern is that there might be data theft, there might be stealing of money in this case, right? So as the market for mobile financial services has developed and grown, the protection of consumer financial information and from unauthorized access should be of prime importance, right? We need to know how to authenticate the consumer's identification to keep the data transfer process safe from viruses and malware and these other attacks. And it's important to have a wholesale approach, so this is covered throughout the entire process. And generally, information held by banks and other service providers is very important, and there's a risk there of leakage through hacking, tampering, unauthorized access. So we need to make sure there's adequate measures and safeguards for consumer data protection. Now, in the United States, there are regulatory measures in place. The first one is called Gramm-Leach-Bliley. This is the U.S. privacy law. And I know in Europe there's a much better privacy law, but you know, as we said, it's geared toward the U.S. market, although we'll touch on some other areas as well. But under Gramm-Leach-Bliley, as with any privacy law, it's important to protect the consumer's non-public personal information, which under Gramm-Leach-Bliley is information provided to a financial institution by a consumer, something that results from a transaction or service from the consumer. So something like a credit card transaction, you're buying that cup of coffee, you're buying your new watch or whatever. Or it's other information somehow obtained by the financial institution. This information, it can include loan terms, lender or mortgage broker names, sales amounts and sales concessions, co-borrower information, unpublished phone numbers and other contact information, and anything really that would be sensitive to an individual consumer. Even the fact that a particular consumer is engaged with a particular lender is considered to be protected information if it has not been recorded publicly or disclosed in some other way. If there's a breach of data security with respect to private information by any entity to whom GLB applies, then that entity would be liable for that breach. Now, we're going to talk about data liability a little later. We're going to talk about the target breach and some of these other breaches in more detail, but generally, Gramm-Leach-Bliley applies to any financial institution or any vendor, a subcontractor of a financial institution, or anyone that's making use of this information. So it can also apply to merchants, to credit card processors, people like that. It's a fairly broad interpretation. It can apply to insurance brokers, security firms, tax preparers, real estate settlement companies, etc. Now, with respect to mobile financial services, there's a question as to whether it applies to mobile carriers like Sprint or T-Mobile or Verizon. And a lot of times you can buy things directly and have it charged to your mobile bill. That's another type of mobile financial services that the carriers have their own system they're trying to develop, but it seems like the NFC, things like Google and Apple iPay and those kind of technologies, I think are going to gain ground and gain more traction with consumers and probably overtake the carrier efforts in this area. Now, there's another regulatory factor to consider. This is Sarbanes-Oxley Act. It's hard to pronounce. This really applies to public companies, any public company in the U.S., but they operate overseas as well. It requires them to have accurate financial information, and it also requires any auditors and subcontractors downstream that contribute to that financial information to ensure that their technology systems and their internal controls are prepared and made in such a way that that information ends up being accurate. It's about giving investors correct information. Now, the way this ties in is it's logical to assume that any data theft or unauthorized access of data might be minimal in terms of Gramm-Leach-Bliley. It may not impact Gramm-Leach-Bliley, but it may impact Sarbanes-Oxley if it affects the financial condition of a company. And this is actually a bigger target for hackers. Hackers may not be interested in your $5 coffee purchase, but they would be interested in J.P. Morgan's reporting information or their financial statements. Non-compliance with these provisions can lead to hefty fines being imposed on the institutions and entities involved. Now, there's some other regulatory measures that I want to just touch on that also come into play for mobile financial services. There are FTC regulations which govern how you deal with customers, consumers, and they apply to anyone, but they especially apply to banks in dealing with consumers. And it involves disclosure, proper disclosure to customers, and not doing anything that's misleading in advertising, things like that. And this all these are laws that were in effect before mobile technology existed, but they still apply. They've been deemed to apply, and common sense tells you even though you're doing something differently, this is still going to apply as long as you're feeding information to consumers. There are also some state data breach disclosure laws here in the United States. We have over 40 different data breach disclosure laws that all have different requirements. There's some movement toward having a federal data breach disclosure law, which I'll talk about a little later. But right now, it's really sort of this fractured structure. And then in terms of financial services, certainly anyone that uses a credit card or payment card is going to be subject to compliance with the PCI data standards, and they actually need to be compliant really before you start using them. If you're not compliant, it can not only lead to PCI fines, but it can lead to liability in the courts. The courts will say, hey, you didn't even bother to comply with PCI. You're certainly guilty. So it's almost a presumption of guilt if you're not in compliance. So the real question here is, what's the liability to banks and their vendors, their subcontractors, right? Is the bank a mobile service provider? How would they be held liable for these tampering of information, even though they're in compliance? They're in compliance with PCI. They're in compliance with GLB. They've done everything they're legally required to do. Would they still be liable? And it really seems that the law is not clear in this respect. Customers still might have recourse against these entities for traditional claims of negligence, breach of contract, breach of fiduciary duty. But it's not clear. There's no clear-cut provision for holding an entity liable for loss of data due to acts like hacking. There are plenty of instances. Target, they just announced a settlement the other day. There's plenty of cases, these big high-profile cases. People are going to sue, and they have claims, but it's not clear how legitimate those claims are or how much the banks and the financial institutions are going to be liable for. The problem is it's just scary because it is an unknown, and you never know if you're going to get a court that some courts, or juries might favor higher awards than others. However, there's an increasing view that the laws in general should be rewritten to assign greater responsibility to service providers and other organizations that handle large amounts of personal information, like a cloud service provider, let's say. And the view is that such organizations should be legally required to inform their customers as soon as there's a hack or any data loss or any data penetration, really, and that they should be held legally liable for the financial impact on their customers as a result of hacking and identity theft. There are laws in Congress, nothing's on the books, but there are draft laws that are being circulated to this effect to impose this higher standard on these companies. So just to summarize and conclude this section on mobile financial services, clearly the amount of transactions are going to increase. There are regulatory constraints that impose these conditions. It's likely those regulatory constraints will increase. And as the number of users increase, it's a greater challenge to the marketplace and the regulators and really service providers and technology people in the industry to handle this. I mean, people want to be able to make payments through their mobile phones. It's something people are willing to provide, but how can you do it in a safe way? And I don't think that a company should be able to handle someone else's money without being regulated or having some kind of oversight, but at the same time, that oversight can't be so strict that it doesn't make business sense for that transaction to take place. Okay, just going to move on to our next section, cloud computing, and keep an eye on the time. I want to talk about the risks of cloud computing. We'll talk about some of the legal and regulatory issues again. We'll briefly talk about negotiation issues and contracting objectives. With the last two, typically in cloud computing, it's not always easy to negotiate. There's often very little to negotiate, unless you're a big player. Big Fortune 500 companies they rarely sign the standard cloud computing contracts. There's definitely, I know plenty of instances of some heavy negotiation. But for most businesses, the contract is pretty much take it or leave it. However, when constructing those contracts and making those service offerings, I think the cloud providers need to take into account some of these legal and regulatory issues because they're going to be held accountable down the road. And if there's a regulatory requirement, even if the contract says otherwise, the cloud computing vendor is going to be held liable. Okay, the next slide, this is one of my favorite slides. It's a great picture. You know, we now live in a cloudy world, right? We have these network clouds, and this is actually an old diagram that I modified from in the late, it was 1998, 1999. We did a lot of network outsourcing, and this was how we sort of described the clouds. Well, this has now evolved. Cloud grew out of network outsourcing, and it's still at its most basic level. That's what it is. But there are these clouds, right? And large multinational companies will have data centers kind of along these lines. There'll certainly be one for Europe. There's data requirements and other things in Europe that are common, so it's easy to have one data center for Europe, a data center for North America, data center for Asia Pacific, and then Latin America as well. So we just live in a world that's segregated in that way, and I think it's good to know, and it's good to set your business model so that you're maybe attacking or addressing one market's needs at a time. So I just want to move a little quicker here. So cloud computing, you know, there's a definition here, but it's really a shared pool of configurable computing resources, right? Whether it's a network, a server, software applications, or literally services, but the services are usually provided by means of some type of software. And it's broken down into three large categories here. So the first is infrastructure as a service. So that's, you're getting X server capacity and Y latency, etc. The next is platform as a service. So maybe you're getting availability to hardware, and you're getting a basic platform, some middleware in which to run your applications. And the last is SaaS, what used to be called Application Service Provider, or ASP, is where you're really sort of making use of some software. It's not on your server, it's on someone else's server, but you don't see any of that. You don't know what's going on there. You're really just using the software, whatever functionality, whatever business model you've chosen to accept. Cloud computing can be used in a lot of ways. It can be the traditional service bureau setup, where maybe you're buying payroll services and it's just a website and you're putting information, you're receiving information. It could be information technology outsourcing, so it's more like the platform as a service or the infrastructure as a service. Or there might be some technology-heavy business process which is useful to outsource. And this happens a lot in financial services, where there's credit card processing as an example of something like that, where there's a lot of technology that happens behind the screen. No one really wants to know the details. They just want to know that it's done correctly, and there's certain restrictions in place. Well, why do people outsource to the cloud? The first might be financial motivation. Maybe it's cheaper, makes sense financially. It might also mean it's easier to identify the costs and segregate those costs and predict whether you're going to save money or not. You can certainly access more infrastructure at a lower cost, and often software at a lower cost. And it allows management to focus on the core competencies of the company, whether it's in financial services, whether it's some type of investment management, or as we said, something in the credit card world, marketing credit cards, or selling insurance, or anything like that. Typically, cloud computing there's a significant resource commitment in the cloud. Right, once these clouds are built, they stay in place. For the customer, there's a fixed contract term, and the contract terms themselves, they can either be simple or complex. I think it depends on the business relationship and really the leverage that the customer has. As I said, for large multinational companies, they typically rarely sign a standard cloud contract without some negotiation. For smaller companies, they just don't have the leverage, so they adopt whatever the cloud vendor is providing. The market for these services and the pricing, I think, is still in flux. There's a lot of competition out there. There's a lot of different service offerings. And I think it's important to do research when contemplating any sort of cloud computing usage, any use of cloud computing. So what are the risks of cloud computing? Certainly there can be security breaches that the cloud service provider doesn't discover. Data can be in jurisdictions without adequate data protection. As we said, there's these different clouds around the world. Typically, there's a European data center. Everyone knows Europe has great privacy laws. Let's put all our data over there, and segregate it. That's one way to ensure that your data is protected. But the question is, are you asking your cloud service provider, hey, are you putting this in the right place? Are you protecting it correctly because the regulations that we talked about earlier, the privacy regulations, et cetera, the regulators don't care if a bank hires a service provider and the service provider makes a mistake. The bank is still going to be held accountable. You're not going to be able to shift liability and just say, oh, I didn't do it, my service provider did. They're going to hold the bank liable for that. And typically, as we kind of touched upon, these cloud computing vendors, the providers, have a lot of discretion in their terms and conditions. A lot of times it's boilerplate contracts. So maybe you can't get something in the contract, but you still need to ask the question, hey, where is my data? How is it protected, etc. Some other risks involve service providers using data for their own purposes, right? Sometimes they'll do data mining, or they typically like to aggregate data and find trends and use that information for other purposes. As a customer, I think you have to question whether you want someone else learning things about your business and then going out and making use of it. And again, I think it's important to have, it comes down to the contracting. There needs to be accountability and responsibility with the subcontractors. If the cloud provider that you're contracting with may have its own subcontractors, people you don't even see, again, people behind the screen, it's important to ask, who are those people? Are they accountable? Can I rely on them? Other risks involve, you're really losing control of your data. Are you keeping backups? Is the cloud provider keeping backups? How difficult is it to get to that data if you need it? Another risk, you're sharing the infrastructure with, who knows? You could be sharing it with a hacker or someone else. So how does the cloud provider address those types of risks? And really, there's less of an ability to monitor your data unless you've somehow put something in place, or the service provider themselves discloses things like the ability of their services to really deliver on what they promise. All important questions to ask when getting into a cloud situation. So let's jump to, how does this apply to financial institutions? Well, in the United States, there's something called the FFIEC. You can see it's Federal Financial Institution Examination Council. And what that is, it's a really consortium of financial regulators, and they issue regulation, and they call it guidance from time to time. It's not necessarily the same as a regulation, but it does carry the same weight. If you're not in compliance, you're going to end up on the wrong side of the regulators, which is not something you want. And they have pretty much come out and said, they've actually come out and said that you need to do due diligence on a cloud service provider. You need to confirm they can comply with any regulatory changes that may come up and regulatory structures that are already in place. You need to be able to audit the IT side of it. You need to have effective monitoring of information security, and to make sure they have the resources so that you can continue doing business, right? You wouldn't want to see your bank shut down because their service provider went out of business, or there was maybe an earthquake at a data center or something like that. And these are important from the customer side, the company buying cloud services, but I think it's crucial for companies that want to provide services to financial institutions need to understand this, because you can come into the marketplace and say, hey, we've got a great cloud offering, and you're going to try to sell to financial institutions. But if you ignore these regulations, you're never going to get traction. You're not going to be able to sell to a big financial institution because they're stuck. They have to abide by these things. Now in Europe, Europe has its own set of privacy regulations, and they actually have they've issued a set of standards for cloud computing, very similar to the U.S. version, but it's actually more detailed. They've got model terms and conditions for service level agreements. Certainly they have data protection, security standards, interoperability and data portability standards. And then they have, for the environmental side, they have standards for consumption and emission, typically with these large data centers. They can use a lot of energy and contribute a lot of heat and carbon to the environment. Briefly, just to touch on case law. The use of cloud computing can, in this first case, increase the number of contacts for personal jurisdiction. I don't know how many lawyers are out there. I don't want to get the non-lawyers rolling their eyes, but really what this means is if you're hiring a service provider who has a data center in Ireland and you're in the U.S. and someone slips and falls at the data center in Ireland, you can be sued. They can say, hey, this court has jurisdiction over you. You've got this. It's not your data center. You're using the data center, but it's been found it can contribute to a finding of jurisdiction there. A similar thing happened with this Cablevision case. The second case is that the company itself was not infringing. The question was, they're downloading all this data and they're putting copyrighted material in the data center, and then it gets copied several times. A similar question came up: is that copyright infringement? This court found it wasn't because they were merely storing it for them. So that's good to know that you're not going to be held liable for that in that situation. And the final case here, this is really Google fighting against Microsoft. Microsoft had been picked for some federal contract, and Google was just fighting, saying it wasn't a fair and open situation. I think it's part of the cloud wars between the big cloud companies. This kind of thing we'll see more and more of. So let's touch quickly on negotiating issues. You really need to address the IT and the business objectives, to know what they are ahead of time and be able to manage those different objectives. There needs to be flexibility in the relationship, especially when you're getting into a situation where you're putting important sensitive data on the cloud. You need to know that it's protected. You need to be able to get to it in an emergency, and you need to be able to. You want to be able to grow, because you start to become reliant on cloud service providers, and it's hard to switch. It's hard to switch to another vendor. So you want to have some flexibility so that from the customer side, you want to grow it. And then from the service provider, certainly you want to be able to grow the relationship with the customer. You want to make it easy for the customer to buy more services from you. So I think an awareness of these issues would help service providers give a better offering and find more traction in the market. Okay. Now, just briefly touch on liability issues. There certainly indemnification is a big issue. To what extent will the service provider be responsible for things like data breaches? As I said, the regulators aren't going to excuse the the financial institution just because they have outsourced their computing services to some cloud provider. So the cloud customer, again, is going to have to look to that cloud provider to say, you know, to what extent are you going to be responsible? A lot depends on leverage, but at the same time, you know, the market reality is that there's a demand for this sort of thing, and the vendors are going to have a difficult time really getting traction, certainly with bigger players in the financial services industry. They might sign a contract here, a contract there at a big company, but sooner or later the CIO is going to get wind of it, and I've seen it happen where, you know, some cloud provider or some SaaS provider has picked off this division, that division, and then all of a sudden one of the C-level executives finds out about it, and they threaten to terminate the contract, or they force them to renegotiate. And you know, with a big enough customer, it's going to have an effect. Consequential damages, these are typically excluded, although there's some confidentiality restrictions that are carved out of that, let's say. And then the contract is usually limited to direct damages. This can work from both sides, and there's actually insurance requirements. Insurance companies typically require some kind of cap. I'm going to go quicker here. We're running low on time. There's other stuff I want to cover. Service levels, I think if you're familiar with this industry, certainly you want to know what service you're getting and have something in place that describes that. For some service levels that are important, you might be able to get service level credits, although that is harder and harder to find with cloud services. Termination rights, you want to be able to terminate, but more importantly, the problem is, what do? It's not always, a termination sounds like it's the right remedy, but for the customer, it's not always easy. How do you get out of that relationship? You've got data, you've got clients using that service or accessing that service through your systems. How do you really address it? And really the big issue here, the last point there, data, that's really it, you know, and that's part of it's a double-edged sword. It's nice to have cloud services that are very useful, but you've got your service, your data, your most important data, you know, can be in someone else's hands, and how do you address that? If you have any further questions in this area, there's something called the Cloud Security Alliance. This is a nonprofit organization that promotes the use of best practices in cloud computing. It has a security, trust, and assurance registry, which addresses security controls, and you can even get a certificate of competency in cloud security issues. Okay, there's something else called, this is internationally, there's an international working group on data protection and communications, which talks about, again, standards, et cetera, internationally. And these are things that bank regulators actually look to and they point to and say, okay, the regulators don't need to reinvent the wheel if this is out there already. And this is something that's fairly well known in the industry. They've made recommendations regarding efforts in further research, privacy, saying legislatures should reassess the adequacy of existing laws because the technology tends to grow quicker than the laws can address. And the legislators are always playing catch up. And then privacy authorities should continue to provide information for parties involved in cloud computing and legislators regarding privacy and data protection. And what I mean by that is that there needs to be a feedback loop and a dialogue between the regulatory authorities and the marketplace, so that, as we said, if you're handling someone's financial information or the money, you're going to be regulated. Now, the regulation has to be reasonable, but it has to reflect the market reality. And having that dialogue, I think, will help address those concerns. Just in summary here, an effective cloud outsourcing contract is going to clearly define the parties' needs and expectations, clarify the services. When necessary, it's going to have thorough service levels, but again, they have to reflect reality and be practical. It's good to have flexibility to deal with future business requirements, and there should be proper communications and relationship between the customer and the vendor. Mostly, if it's good business for the vendor, it's important for the customer so that they can make sure their needs are met. Let's jump to information governance, and again, we're running low on time, but I want to talk about this a little bit. There are really several different types of information. There's personal information, which we talked about. There can be private information, that non-public information about the company, how it's doing financially, etc., that needs to be protected. And there can be other information that for some reason you're contractually obligated to keep secret, whether through an NDA or some other reason. And then there's trade secrets, intellectual property of the company. And it's important to distinguish between these different types of data when you're using a third-party service provider. Do I want to risk putting my data with this service provider? What data am I sharing? That's part of information governance, is the new buzzword for this, and it's really taking a holistic view of how data is treated at large companies. Data analytics, big data, talks about really understanding the trends and the needs of your customer. And I mentioned briefly, sometimes the third parties, cloud providers, will want to use your data, run their own analytics on it, and look for trends in the marketplace. Now, maybe the solution is to have them report the results of those analytics back to the financial institution, and so that the financial institution can gain from it. Another area under information governance is record keeping. This actually varies by regulator. That can be the same type of information, can have different record-keeping requirements depending on whether the financial institution is governed by the SEC, regulated by the SEC or the FFIEC, or even with insurance companies, it can be a state-by-state record-keeping requirements. It's because record-keeping is now all done electronically. This again, it falls into data. This is an area that cannot be ignored. It sounds like something sleepy, boxes in a warehouse, but it really isn't. It's data off in some data center somewhere. Electronic discovery is, we lawyers are familiar with that. Again, this is data and records, but how does this come up in litigation? How can we get our handle on it? You can't tell a court, oh, I just couldn't find it. I mean, that doesn't fly with courts. And also, it's important for internal investigations. There may be some reason to do an investigation for the company for its own purposes, whether by some errant employee or some other situation. So it's important to be able to manage data. And finally, talk about data breaches. We've got two large breaches here. JP Morgan Chase was recently breached, and they found it had been going on for a long time, that the hackers were basically sniffing around inside JP Morgan's systems, trying to find vulnerabilities. They weren't sure how much data has been turned over. In fact, they didn't think there was very much, but just the fact that they were in there looking around was a very creepy thing to me. Target, again, was a data breach, and I've included that here because this is really a PCI, credit card issue. And I think Target's not a financial institution, but they certainly are in financial services. And I don't know how much you guys have read about it, but there were two instances. The initial access was done through a heating and air conditioning vendor that had access to Target systems. They somehow got their login information. And then there was another instance where there was actually software on Target systems that was designed to detect a data breach. It detected it. It wasn't properly configured. It could have shut down the data breach, but no one had bothered to configure it for that. So there was even one report that said that the IT guys saw a breach and they said, we don't need to worry about that. That's a false alarm. And it ties into PCI compliance because you can be PCI compliant, still have a data breach, and still have liability. Which is going to bring us to the last topic here, which I'm going to wrap up quickly. Cybersecurity, right? This is something that we all face from all different levels, right? As individuals, we're concerned about people getting our information, identity theft, things like that. As businesses tend to be the bigger targets. It certainly makes sense to go, if you're a hacker, it would make sense to a hacker, it doesn't make sense to me, but to a hacker to go after a business and rather than an individual. No one's going to care about my bank account, but they do care about Chase's systems and accounts. And then really as a country, we're constantly under attack, not just the government systems, but globally. We have large multinational companies that really operate across countries, and we really need cooperation. One of the solutions is really governmental cooperation across countries internationally to address this problem. And I was going to say solve the problem, but I don't know that it is solvable. Maybe someone out there is smarter about technology than I am, but they say there's two types of companies that know they've been hacked and companies that don't know they've been hacked. So I don't know that there's an end to it, but I do have hope. I think there's solutions that businesses are going to provide, and that's part of what. Let's just jump to my summary here. There was a National Cybersecurity Task Force. It was launched by Bush and still continuing under Obama to address cyber threats. I know there's a task force that I belong to in New York. We have quarterly calls with the FBI and Homeland Security and some other law enforcement agencies that talk about different threats that are out there and how people are combating them. But in conclusion, just to talk about all this in general, I really want to say that there's a few things that we need to keep in mind. Number one, there's always a human element. No matter how much security you have, no matter what your contract says, there's always a human element, right? In Target, the whole situation where they knew they saw an alarm for a breach and they just decided it wasn't important. So, people make mistakes. I think the way to address that is through training and having accountability. Also in Target, again, makes a great example, vendor management is important because you're hiring other companies to provide services, but you need to oversee them. The regulators aren't going to excuse financial institutions because their vendor made a mistake. They're still going to hold the financial institution liable. And so there needs to be some kind of regular routine oversight of service providers. And service providers who are in this industry need to understand that that's got to happen. If you're going to sell to large institutions, you're going to provide services, you're either going to be subject to these regulations directly or you're going to be selling to someone who is, and you're going to have to help them. Otherwise, they're not going to be able to hire you. They're going to have to look for someone else who's willing to do this. And the last point here, meet the new boss, line from the Who song, same as the old boss. There's a lot of laws and regulations that are on the books that were written before we had mobile financial services and cloud computing and, Google Wallet and Bitcoin and all this stuff. Regulators are trying to catch up with it, but at the same time, there's plenty of instances where they can say, hey, look, you're not allowed to false advertise to your customers online. We said it before, even just because you're doing it now, maybe it's not a print ad, maybe it's an online ad, maybe it's a mobile ad to their phone. Excuse me, that law still applies. So the regulators aren't going to go away. They're going to play catch up to some degree, but it's easy enough to look at the old laws and understand what's likely to happen going forward. Excuse me. And the final point I want to make, and then we can open it up to questions. I know we're getting close to time. It's just that financial services, I think, are ripe for innovation. There's a lot of large banks and investment houses out there that are heavily regulated. The insurance companies very heavily regulated. And they're big, old, clunky companies, and they have a difficult time being innovative. The sector needs innovative solutions. It's crying out for them. I think there's a lot of opportunity. I know in London they're very focused on growing the FinTech area and having startups and other companies in this field. I think that's a great idea. We have something here in New York, and I think we, between the two, London and New York, hopefully we can beat Silicon Valley, at least in this area, because I think we really have the expertise here in order to do so. And I just think there's a lot of opportunity, and I'm very excited about this area. And thank you very much. Hopefully we've got time for a couple of questions.
Okay, thank you very much, Kevin, for such an interesting presentation. I'm sure you've given everyone listening a lot to take away and think about. Unfortunately, we're running out of time now, so it just leaves me to thank our speaker today and to remind you all that the recording will be available on bobsguide. Thank you for attending today, and we look forward to welcoming you to another bobsguide webinar in the future. Goodbye.
And just want to say, if there are any questions, feel free to reach out to me on LinkedIn or online, and I'm happy to talk to you. Thank you very much.